Good evening. This is John Milburn for Laws 12059 Conveyancing. This is week 7. We're working our way through the material, not week by week in accordance with what's in the study guide. We are behind a couple of weeks, but we are working our way through the curriculum, and you'll probably note that there's a week or two spare for us to have plenty of time to catch up by the time we end the unit. The first thing that I would like to do is talk about the second assessment. The results are all out now for the first assessment. Thank you very much for participating in that exercise. I hope that you found it gave you some freedom. There was no one right or wrong answer. We had a multitude of different responses and they were all very good, overall very good. So thank you very much for participating in that. In the second assessment, we get down to business a little more seriously. I'm going to share the screen. We're looking at the second assessment, which should be on your screen now. Please let me know if that's not the case. So the second assessment is due on Thursday, the 20th of September. As usual with my assessment work, there is the penalty of 5% deduction for each day of late submission, and there is a final cutoff. If you do not submit your work by the 29th of September, then you will not receive any marks. This is worth 30 marks of the overall assessment, and it's a single question. I'm not allocating marks for individual aspects to the question. That is intended in part to provide you with maximum degree of flexibility. Also, if I prescribe individual marks for the question, in some ways it gives away the answer, and I hope you understand that. So I'm giving you a maximum discretion here, and I encourage you to talk about this assessment amongst yourselves, provided you don't collaborate. That you don't collude. You can certainly collaborate. And as a group, I'd encourage collaboration through UCrew. If you have a question about the assessment, please send me an email, or better still, ask a question through UCrew. You'll see the rubric that I've adopted for this session. And the question that I've given you in the second assessment is a format that I use quite often, that is assuming that you're a first-year lawyer in a law firm. Now, I appreciate that many people doing this unit or this course, laws at University of Queensland, will not practice. However, asking questions as if you're in the hot seat, as if you have to give advice, is, I think, a good way of testing your knowledge generally. And the idea is that you're providing advice to a partner in the law firm, so you're providing the advice to an educated audience. That's quite intentional because you have a tight word count. You don't need to talk about basic aspects of law. You can get straight down to the heart of the issue, knowing that the reader has some background in legal issues. One change that I have made, and thank you, I think, Rachel, for bringing this to my attention, is this. On the second line of the interview, I've now deleted 3 words. Previously in the first version it said, she said that she and her husband signed contracts, I think, 2 days ago. So I've taken those words out so that we're now talking about an interview. The rest is exactly the same. The interview is on the 19th of September and the contract dates are the 1st of September. Otherwise, everything else is the same. So your task is to consider the contracts, consider the problems that have arisen, and provide advice to the clients, but in the form of a memorandum to the partner. And I think I'm required to provide a pro forma, which I haven't yet done, of a memorandum, but don't be too concerned. There's no set format for this. And you could just use a memorandum out of the Word program. You can put a cover sheet on it if you like. Cover sheets are probably good, but you don't have to. But do make sure of some basics. You'll know that I want you to paginate your material, even if it's in a memorandum. I use footnote referencing and use the AGLC3 for your referencing. So are there any questions then about what is required for the second assessment and how I would like you to present your work generally? All good?
John?
Yes, Sarah?
Sorry, I'm a little bit hoarse. I've got a cold. Just out of curiosity, what weeks are actually needing to be covered in this particular assignment, if you can disclose that?
Yeah, I don't really have particular weeks in mind. I know that makes it more difficult for you to prepare, but you can consider everything that we've covered as being accessible. And whilst I'm not asking you to necessarily do this, even if you go ahead, there may be some hints in there that you can use and incorporate, if you like, for bonus points. So, and you don't have to restrict it necessarily to just what's in the conveyancing material. I know I'm touching on dangerous territory here because people will say, but it's not fair if I'm asking you to add in other material. But the idea is that you become as resourceful as you feel you wish to do. And if you feel that a certain remedy requires you to introduce material that's not strictly in the textbook, then feel free to do it. But you don't have to. I hope that answers your question, Sarah. Thank you. Any other questions, comments? All good? And those that are watching as a recorded session, please feel free to ask questions as we proceed. All right, so last week we talked about issues to do with the signing of contracts, in particular the electronic signatures, and we started to talk about some equitable principles. I take it you've all done equity or trusts or both, or at least you might be doing those. So doctrine of part performance we talked about. We talked about this in the context of you as a conveyancer being put in the hot seat and being asked to ask and to answer questions and to interpret information that is exchanged. The other thing that we talk about usually when we're talking about equitable estoppel, when we're talking about part performance, are issues to do with waiver and equitable estoppel. So when you're looking at a question where, for example, a conveyancer has said something or omitted to do something in the context of an exchange, you'll be asking yourself, was there a variation to the contract? Was there some other form of waiver to the terms of the contract, which amounted to, if you like, a de facto variation to the contract? Have there been some acts of part performance? Has there been a waiver of rights? And all of this is also tied in with issues to do with equitable estoppel. So they're the key things that you need to consider and be prepared to discuss in these type questions. Type questions, again, are those where the conveyancer has, for example, agreed to grant an extension or given an indication that an extension might be approved. Is that a waiver? Is there an estoppel? Is there some sort of part performance? Now, bear in mind, of course, that Section 59 of the Property Law Act, which I'm sure you're all familiar with, is the evidentiary provision, the enforcement provision in relation to the requirement for a contract to be in writing. But it's not absolute. And if you want to argue to get to circumvent Section 59, probably the best way to do that is to raise an argument based around equitable estoppel. But it's very difficult to run an action for equitable estoppel in this context. The assumption or the representation that fostered or encouraged or was ultimately relied upon needs to be very clear, to be enforceable, notwithstanding the requirements of Section 59. So if there's a failure to record an agreement in writing, and you're going to argue that the other side is stopped from denying the existence of the agreement to the point where the oral agreement should be enforceable, there are some rules that you need to consider. You need an explicit assurance that the statute would not be pleaded. In other words, you need something more which led a party to reasonably assume that the other party would honour the agreement despite the absence of writing. You need to establish that the other party acted unconscionably. So simply by suggesting that there was an agreement that was oral or there was going to be an agreement in writing without more is not enough. So the critical elements of equitable estoppel are that there was a detrimental reliance by one party on the behaviour or conduct of the other, which typically is manifested through some sort of representation, and that the other party's conduct was unconscionable. So you can see the difference between arguing for an order around equitable estoppel and simply trying to enforce an oral agreement. They're quite different, even though on the face they look the same. So the leading case, we talked about this I think last week, Walton Store against Marr, 1988, 164, CLR 387. That was in the context of negotiations for a lease. The parts of the agreement were concluded, terms were agreed, but parts were not exchanged, and the conduct of the parties was such that the proposed tenant believed that the exchange would occur. There were significant acts of part performance, and it was held that the Walton's behaviour was unconscionable. Marr had suffered detriment while relying upon the assumption that Walton's had created, and the reliance on the assumption was reasonable. Therefore, equitable estoppel did arise for Marr in that case. When we're talking about variations to a contract, even say an extension, of course it's good practice to put this in writing. But there are a couple of questions. One is, does it have to be in writing? The answer is usually no. But the second, and we talked about this last week as well, is does granting an extension without more nullify the time of the essence clause? Now, according to Tropical Traders against Coonan, 1964, 111 CLR 41, it can nullify time of the essence, but generally it doesn't. But this is you've got to be very careful here. So the buyer in that case who relies upon the promise of postponement may be able to prove the necessary requirement of detrimental reliance in order to establish estoppel. But the argument has some merit, but my view is that unless you specifically state the time is of the essence in granting or asking for an extension, then despite what's said in that case, my view is that you're probably going to find that time is no longer of the essence. And that the good practice would be, rather than to purport to terminate immediately, you attempt to reinstate time of the essence. And the procedure for that is what? If you find yourself dealing with a contract where time is not of the essence, or a contract where time was of the essence, but now it is no longer of the essence, or it's not likely of the essence, what do you do to make time of the essence once again? What's the procedure? Any thoughts? Rachel says, in writing with consideration. Maybe, but the fact of in consideration suggests perhaps that there's an agreement. So I guess my question is more, how would you unilaterally establish time as the essence once again? I think the answer to that is that you give a notice to complete. You serve a formal notice to complete, and in that notice you provide reasonable time, whatever that might be. And the courts haven't specified what reasonable time is. It's relative to the contract. We'll talk more about that in the context of installment contracts, where it is sometimes necessary to instate time of the essence. All right, any questions so far? Good. Now, formation of contracts, the cooling off periods. I think we all know about the Property Occupations Act, and we're going to talk about installment contracts and some prohibited transactions. So cooling off period, see the Property Occupations Act, residential property sales, sections 159 through to 168. That was a common mistake in the first assessment, in that people were not making it absolutely clear to the reader that the cooling off provisions only apply in relation to residential property sales. Does it apply to all residential property sales? Are there any exceptions? So and
you can waive the cooling off period.
You can waive the cooling off period, and auction was the answer I was looking for. And bear in mind that auction is defined more than just the fall of the hammer, so to speak. It goes a little beyond that as well. All right, so thank you. So instalment contracts, who knows where we would look for information about the law relating to instalment contracts? And can anyone tell me in general terms what we mean by this phrase instalment contract? Any thoughts? Firstly, the legislation. Yes, Bronwyn?
It's a contract where you're not necessarily, you're paying either a higher than 10% deposit and it goes into, can extend out longer than the actual contract date, or you can make it into sort of, you know, payments over a 12-month period or something like that, where they can create an instalment contract.
Great. Yeah, I think you're very much along the right tracks. To me, the phrase instalment contract is somewhat of a misnomer in that when I think about a contract by instalments, I think about a contract where I'm required to pay for the ultimate price by a series of progress payments. That's the way I think when I think about a contract by instalments. But an instalment contract is not like that. An instalment contract, as Bronwyn rightly points out, is defined, it's determined by reference to the extent of the deposit paid. So the definition is in section 71 of which Act? Is it land title? Is it property law? Is it property occupations? What are the votes? We've got one vote for PLA. Yeah, we'll give it to PLA. Okay, so it's the Property Law Act. So section 71. So if you have access to the legislation, have a look at that as we speak. You'll see the definition of instalment contract. It means an executory contract for the sale of land. What do we mean by that term, executory? It requires something to be done. Future contracts, that's it. Yep. So when we talk about a contract, a signed contract, it is, in the context of conveyancing, typically an executory contract. We don't say that, but it is. And the difference is if you purchase ice cream from an ice cream shop, you exchange money for the goods straight away. So it's a contract which is executed, as opposed to an executory contract where you're making a commitment to do something down the track. And recall that was a point raised by His Honour Justice Keane in one of the cases we talked about last week. So an instalment contract is an executory contract for the sale of land where the buyer is bound to make a payment or payments other than a deposit without being entitled to receive a conveyance for that payment or payments. Now, what does that mean? So bear in mind that the word deposit is also defined. Deposit means a sum not exceeding the prescribed percentage, payable under an instalment contract, paid or payable in one or more amounts, and liable to be forfeited and retained by the vendor. Now, the prescribed percentage for the contract of a sale of proposed lot is 20%, but otherwise it's 10%. So a proposed lot, we're really talking about the Land Sales Act there. So leaving aside issues to do with off-the-plan contracts, Land Sales Act or BCCM in the context of units, the nuts and bolts of instalment contracts relate to the sale and purchase of real estate, which is in existence, and 10% is the magic figure. So if the buyer is required to pay something more than that deposit of 10% without being entitled to a conveyance, then we have an instalment contract by reference to the definition. Does that make sense? So in English, if it's more than 10%, it's going to be an instalment contract. Section 71A talks about the application of the division. It does not bind the Crown. Does that surprise you sometimes that legislation either binds the Crown or does not bind the Crown? So the Crown's not bound by this. The idea is that the Crown is not bound by all legislation, because if it was, the ATO would have to pay tax on the money it receives. That's part of its business. You understand? So that wouldn't make sense. So in this instance, the Crown is not bound. And Section 71A, subsection 2 says that where a contract for the sale of land may at the election of a buyer be performed in a manner that would constitute an instalment contract, it shall be presumed to be an instalment contract within the meaning of a section. Now, the key part is Section 72, which says that the vendor has a restricted right to rescind where we're talking about an instalment contract. And Bronwyn was right in saying that where we have, if you like, a standard contract where the deposit is 10% or less, time is of the essence, then the vendor has really no restriction on an ability to rescind for failure for the buyer when the buyer fails to pay the final payment. But that's not the case in an instalment contract. So Section 72 says that an instalment contract shall not be determinable or determined because of default by the buyer in paying any instalment or sum of money other than the deposit until the expiration of 30 days after service of a notice in the approved form. So the 30 days doesn't start automatically. It starts after it starts from the giving of the notice in the approved form. So in order to, if you like, make time of the essence in an instalment contract, the vendor needs to do something to create that essential, that time being of the essence. And that's the giving of the notice and giving 30 days. So by this legislation, that gives you some idea as to what Parliament thought was a reasonable time in order to put the buyer on notice that they need to rectify, and only then would the vendor have the right to terminate or rescind the contract. The vendor is not allowed to mortgage the property. That's in Section 73. Section 74 says that the buyer has a right under an instalment contract to lodge a caveat, which will forbid the registration of any instrument affecting the land until completion of the instalment contract. Why do we need that clause? Doesn't every buyer have a right to lodge a caveat if they've signed a contract? If so, what's the difference? Any thoughts? I think the difference is that in the context of an instalment contract, it's non-lapsing caveat. Whereas in the context of a caveat per se that a buyer might lodge, it will lapse unless the buyer takes action to enforce the buyer's perceived rights under the contract. So a caveat, other than in the context of an instalment contract, is usually lodged in circumstances where the buyer intends to litigate or seek a declaration of some sort, as opposed to an instalment contract where it is there as an end in itself rather than a means to the end. I hope that makes sense. Please tell me if I'm going too quickly, but and ask any questions as we go. Section 75 is interesting because it says a buyer who is not in default under an instalment contract after paying an amount equal to 1/3 of the purchase price may give a notice to the vendor requiring the vendor to convey the land to the buyer and at the same time execute a mortgage in favour of the vendor to secure the outstanding money. So you can see that there's this grey area with instalment contracts. The percentages that are critical for an instalment contract in the usual sense are 10% or over 10% and under 33 1/3%. If you go over 33 1/3%, then the whole transaction can, at the buyer's election, be changed so that it becomes almost like a vendor finance situation. So if you're in a situation where you're arguing about instalment contracts, what are the questions that the court will need to consider? What are the questions that you need to consider in putting forward arguments? Then the first is this in fact an instalment contract? You might think that's painfully easy to determine, but it's not. There are some circumstances that make it tricky. But the general rule, more than 10% that's required to be paid without receiving conveyance, it's going to be an instalment contract. Question number 2, if so, if it is an instalment contract, is the seller required to give notice pursuant to section 72, which is the 30 days notice? Probably. Number 3, has the seller validly terminated the contract? Number 4, if so, is the court prepared to make the declaration? Because the court won't necessarily make the declaration. Is the court prepared to declare the deposit forfeited? Is it willing to order that the buyer pay the seller default interest on the deposit? And if so, from what date? That's number 4. Number 5 is the court willing to order damages beyond the deposit? So there's a few questions that you need to ask. So these discussions can be summarised in 2 parts. Firstly, to do with the existence or otherwise of an instalment contract, and then secondly, the issues surrounding time of the essence. Let's deal with part 1 first, which talks about instalment contracts. So the threshold question always will be, are we dealing with an instalment contract? If so, special rules apply. If not, ordinary conveyancing principles apply. We now know what an instalment contract is. We look to section 71, we look at the definition. This is in the Property Law Act. And you'll see that there are 5 factors. Number 1, it needs to be an executory contract. Number 2, for the sale of land. Number 3, where the purchaser is bound to make a payment or payments. Number 4, other than a deposit. And number 5, without being entitled to receive a conveyance. An entitlement to receive conveyance, what does that mean? Can anyone give me a word to replace that?
Without a transfer.
Yeah, yep, I'd say, yeah, that's right. I was thinking settlement or completion, but I think you're right. Once you've got that transfer once you've got that transfer in your hands, it's effectively settled. So correct, yes. Without receiving the conveyance, that's even better a response. Thank you, Rachel. So without receiving the transfer. Now, can I just, as a point of terminology, just to digress for a moment, just this word settling. I use it somewhat interchangeably between settlement and completion, and various iterations of the REIQ contract have actually gone between the two. So it's never really been settled. So you might find that some of the older conveyancers, the older lawyers, they might talk about completion, which is really settlement. Typically in the conveyances, we still talk about settlement mostly? Yep, okay. So settlement is both a process, which is the exchange of money for the title. So in that context, one is said to settle, that is the act of effecting settlement. And number 2, settlement is an event. So it's used as a process, which is a verb, but it's also used as a noun, being an event, to attend at settlement, as opposed to the process. So it's an event where the process takes place. Anyway, I don't know if that means anything, but I thought it's interesting. So settlement or to settle, to complete, about the same. So for simplicity, that entitlement to receive a conveyance means settling or settlement, or I think Rachel's probably right, just receiving the transfer. Okay, now, you would think that you would know the moment you see a contract, whether it's an installment contract or not. How would you do that? First thing you do, look at the amount of the deposit. Now it's called a deposit, but under installment contract terminology, a deposit so-called is not really a deposit, because that amount which goes beyond 10% means that it no longer has at law the status of a deposit per se. So if it's more than 10%, that's an installment contract. But an installment contract may come into being as a result of what happens during the course of the conveyancing process. Have a look at a case called Braidotti against Queensland City Properties. That's BRAIDOTTI against Queensland City Properties, 1991, High Court of Australia, 19. And in that case, with the addition of interest, the contract became an installment contract. There's a lot more to it than that, but that's basically the rule. So a deposit, of course, means a sum not exceeding the prescribed percentage, payable in one or more two amounts, liable to be forfeited. So the third limb of deposit includes an amount that is liable to be forfeited and retained in the event of a breach by the buyer. So there's a few refinements to this. So I'll just say that again. An amount liable to be retained by the vendors, whether the purchase has breached or not, is arguably not part of a deposit for the purpose of determining that amount pursuant to Section 71. Have a look at a case called Starcode Developments against LAD, L-A-D-D, 1999 to QDR, Queensland Reports, 542. In that case, the contract was varied for the payment of interest on the deposit to the seller before settlement. The standard contract provides for the stakeholder to invest the deposit and the interest to be accrued for either of the parties, depending on who's entitled to it, at the end of the settlement or when the contract is terminated. But in Starco, the variation was such that the agreement authorised the stakeholder to pay the deposit and the interest to the vendor immediately, so not at settlement. In that case, the court found that there were instalment contracts. The default interest was payable before settlement. The parties had varied the terms of the agreement by making the authority to pay immediately in circumstances where there was now more than 10% paid, and still in circumstances where the buyer was not entitled to receive a conveyance. So, in fact, I think the case, in that case, the interest that they asked for was about 22% on the outstanding amount, so it was very high. So that was part of the rationale. So when you're looking at it, you need to consider whether or not you're asking for this money as part of the contract, or you're asking for the money to be paid as a collateral agreement. There's a bit of a significant difference here, because if it only becomes an installment contract under the definition if the amount of money that the buyer has to pay is pursuant to the contract, and the terminology is not exceeding the prescribed amount, liable to be forfeited in the event of breach of contract. So a way to get around this is to, in fact, have a collateral agreement, a side agreement, which is not a variation to the terms of the contract. If the contract was not an installment contract, then as a seller, you don't want to do something that will make it become an installment contract, if that makes sense. Another case to look at is Phillips against Scottdale, 2008 QCA 127, and in accordance with a special condition, the deposit was to be paid immediately. The question was whether the deposit, the payment to the deposit holder was a deposit within the meaning of Section 71. In this case, there was $3.5 million contract, $200,000 deposit with a special condition that the total amount to be paid by the sellers immediately, this $200,000, buyer have no claim against it, and nothing will prevent the buyer from recovering the seller under any entitlement at law, and the deposit was released immediately. Now, it was held because the deposit was less than 10%, but still liable to be forfeited. It was held that the release was conditional and feasible. It was paid, but it wasn't forfeited because it could have been clawed back in some way or another. Again, we had a decision of Justice Keane in that case. And if you're looking at the decision, look at paragraphs 21 through to 23 and then 27. There are quite a few cases on this area. I won't go through any more than that tonight, but if you wanted to extend your knowledge in the area, some of the cases to look at, Jack's Lawn's caveat. That's going to be tough because it's an unreported decision. There is a case of Kaneko and Crawford, 1995, QCA 384. They're probably the main ones. So what I might do is post some material in UCRU around those two cases, just to supplement what we've been talking about tonight. It can become quite a technical area, even though on the face of it, it looks fairly simple. Now, are there any questions about installment contracts? All good? Okay. I'll put those two cases on UCRU. So let's move on to a different area. Time of the essence. So still within the context of settling and breach, there is this issue of time of the essence. A handy case to refer to is Legione and Hartley. That's Legione against Hartley, 1983, 152 CLR 406. In that case, the argument was whether the sellers had lulled the buyers into thinking that the essentiality of time would not be insisted upon. And the court held that the off-the-cuff comments by a conveyancing clerk was to be considered in that case. And that's where that case is really important, in the sense that if you're going to make any comments, then you need to back it up with clear instructions from your client. And in that case, the buyer was unable to complete on the nominated settlement date, even though there had been this off-the-cuff statement about granting an extension. Another case on that same area is Tanwa Enterprises against Cauchy, C-A-U-C-H-I, 2003 217 CLR at 315. So in that case, I'll just briefly mention Tanwa is the buyer. It enters into a contract to buy 3 properties from the seller, Cauchy. There's a problem on settlement day. Funds are held up in Singapore in transit. Now, bear in mind, in this case, in Tanwa, as is usually the case, time is of the essence. The buyer didn't attend settlement, the seller terminated the contract immediately. The buyer had funds available the very next day and announced that the buyer was ready, willing and able to effect settlement immediately. The matter went to court. What do you think the court said? Went to the High Court. Part of the argument was that it is unconscionable conduct on behalf of the sellers to terminate the contract in the way that they did, given that the circumstances were outside the control of the buyer. They were caught up in a bank in Singapore, and that the amount which was effectively forfeited was very substantial. Do you think that the sellers were unconscionable in that case? So we'll go with a yes or no. Who says yes? The sellers were unconscionable. We're getting some different votes, a yes and a no. Any other votes coming in? All right, so in this case, the High Court said it was not unconscionable to terminate the contract. The court did acknowledge that equitable relief may be available, but said only if there's a fraud or a mistake, accident or surprise. And the question was determined around the circumstances. So here's some of the questions that the court asked. Did the seller contribute to the delay? Was the breach trivial? What damage did the seller suffer in those circumstances? What was the magnitude of the buyer's loss or the seller's gain? And would specific performance be open for the seller? At 27, the court said, and this is about Legione and Hatley, that case made it clear that the principles identified as promissory or equitable estoppel may operate to exclude the enforcement of contractual rights and may stop a party from treating the contract in question as terminated for failure to meet an essential term. However, in this case of Tanwa, the court really emphasised the fact that time of the essence means time of the essence. And the way I read that decision, unless the buyer in some way contributed, then it's going to be a case of too bad, so sad for the buyer. They lose out. Let's just take another couple of examples. And the next one is Land Bank Tanana against Mackay. It's Landbank, Tanana, Tinana, which is a suburb in Maryborough, against Mackay. This was 2006 QSC 55. All right, so here are the facts. And we'll see which way you think the court should have gone. Purchase price, $800,000. Deposit, $75,000. The contract was made subject to development approval, and the buyer spent, pre-settlement, $191,000 on getting the development approval. The seller said, that's fine, but you do so at your own risk. The contract nominated for settlement to be at Caloundra. There were several extensions. On each occasion, the extensions maintained the essentiality of time. So time remained of the essence in each case. So what happened? At 4:38 p.m. on the Friday prior to settlement, the buyer's solicitors requested a further extension by a few days and offered to increase the purchase price by $10,000. At 5:10 p.m. that same day, the seller's solicitor said their client is away, they have no further instructions other than to request a settlement on the Monday, on that Monday. So on the Monday, the defendant's solicitors said the client is not prepared to grant the extension and would not hold and wouldn't settle. So the buyer did not commence efforts to transfer funds until 11:30. So essentially, the buyers had asked for an extension, they offered some money. The sellers on the Friday said, we don't know, buyer's away, we'll tell you on Monday. Monday morning, the seller's solicitors say to the buyers, no further extension, settlement today. Anyway, the buyers didn't commence their efforts to transfer funds until 11:30. They actually had the money. The money was paid into the buyer's solicitor's trust account, and the buyer solicitors were to send the money to the seller solicitors for the seller solicitors to act as unpaid agent to effect the settlement in Caloundra. But what happened is that the instructions were given to the bank ultimately too late. The bank couldn't organise it. And at 5:07 that afternoon, on the Monday afternoon, the seller solicitors advised the contract was terminated. What do you think? In light of Tanwa, how do you think the court responded?
I think the sellers had something to do with the delay because they didn't get back to them in a timely manner on the Monday.
That was a big part of the argument. Yep. So would you...
And also granting several extensions over time, it wouldn't be unreasonable to think that you would be granted another extension, particularly with more consideration offered.
Okay. So that's another, so like a continuing course of conduct type argument. All right. So the consensus would be, well, they did have their money. They should have had their money in the trust account, said Sarah. Leone agrees. The fact is, the court said, like it or not, you weren't ready. And they asked for the extension on the Friday afternoon, but left it till very late. The sellers got back to them on the Monday and said no. And for some reason, they didn't start the process of getting the funds transferred until 11:30. So in that case, the court, which was the lead judgment was by Justice De Jersey, as I recall, said the buyers had failed to settle, the sellers could lawfully terminate the contract. And at 27, His Honour the Chief Justice at the time, Chief Justice De Jersey, was quite damning. The plaintiff was foolhardy not to make arrangements against the contingency that a further extension would not be granted, even though there had been extensions granted in the past. So the buyers lost, in that case, lost their deposit. Let's take another example now. This one is Jefferson's Road, Jeppesons Road, Pty Ltd against D. Domenico, DI, new word DOMENICO, 2005 QSC 66. Again, a time of the essence issue. So here are the facts. First, time is of the essence. The buyer's financiers send funds through to a local firm, it was actually in Hervey Bay, but they provided the funds into the wrong account. Ultimately, the buyer was not ready to settle until the next day. The buyer would have been able to settle on the day had the funds been sent to the correct account. What had happened is that the buyer's solicitors used a town agent and they sent the money, as they had done in the past, into a bank account for the town agent without realising the town agent had changed bank accounts. So the money didn't make it through to the solicitors, the local solicitor's trust account. Do you understand the scenario? All right. So what do you think the court said in that case? And you can take it that the seller terminated the contract at the first opportunity. Okay, so out of the buyer's hands, unconscionable. Any other thoughts?
Based on the decision before, it was probably bad luck. You should have got the numbers right.
So, and that was a big part of it. So in Jefferson's Road, which was 2005, actually it just preceded Land Bank by 1 year. So I'm doing these in slightly the wrong order. But again, based on the logic of Land Bank, we would say too bad. Leone says the buyers were ready. Wasn't their fault. I guess as a subtext, and unconscionable of the sellers. All right, well, in this case, again, the court consistently said the contract was properly terminated by the sellers. The deposit was forfeited. At paragraph 84 in the judgment, it says, the negligence, and this is a strong word, they use the word negligence, the negligence of the buyer's financiers' solicitors was not an accident. The circumstances are not sufficient to invoke the assistance of equity to grant specific performance to the buyers, notwithstanding the breach of the essential term. It was not unconscionable of the sellers to rely on their legal rights to terminate the contract once the essential time of the essence was breached by the buyer. The contract was clear, the outcome of its breach, while unfortunate, was predictable. The plaintiff must find its remedy, if it has one, elsewhere. It is not entitled to specific performance of the contract. Its claim is to be dismissed. So again, the court have taken a very hard line. You can read into that, in both those cases, arguments to the effect that the seller didn't do anything wrong. The fact is that things were in the wrong on the buyer's side. It's all very well to say, I'm sorry, it's almost like, the dog ate my homework. It doesn't matter. The fact is that the homework's not there. You haven't settled. It wasn't the buyer's fault, and the sellers are entitled to take a strict view. So what do we learn from that? That you've got to be so careful if you're acting for the buyer in particular to ensure that your funds are there, and you can't assume that any good excuse is to be considered by the courts as a good excuse. Does that make sense? All right. Now we'll just move on to week 7 material, which is the subject matter of the sale. And the first thing is the deposit. So you're being very patient with me. We'll just do a little bit on deposit, and then we'll probably haven't got time for a case, and we'll finish with we'll start with a case next time. So as part of your preparation for next week's session, please read the material about deposits, and the next case that I've got for you will be the seller instructs you to terminate a contract. We'll deal with that later. So what is the deposit? Well, it's a part payment. It goes towards the purchase price. That's one thing. Second is it's a guarantee of performance by the buyer. The third thing is it's an amount liable to be forfeited upon default by the buyer. Now, the deposit may, in fact, very often does, become in separate payments. I won't use the word instalments, that would be misleading. But very often a deposit is in fact in 2 parts. So the reference schedule to the contract actually provides for that. It talks about an initial deposit payable on the day the buyer signs the contract, and then it talks about the balance of the deposit. Have a look at section or clause 2.2 of the contract of the standard conditions. And the buyer will be in default if it doesn't pay the deposit when required. We've seen that in a couple of cases tonight, and the seller may recover that deposit which has been paid, or if it's unpaid, may sue as a liquidated debt and keep the property. So strict requirements in that regard. Okay, any questions about what we've covered tonight? Comments? All good? Okay.
Hey, John,
Yes,
just
Sarah?
quickly, just in real life circumstances, I mean, a lot of our contracts only have a deposit of, say, $1,000. Would you really go to court for $1,000? Like, would that be something you would ever advise? Like, to me, it just seems crazy to even consider that for the sake of, say, maybe 1 day extension. I don't know what your thoughts are.
No, I agree. I just think it's almost a joke. So firstly, there's no legal requirement that there be any deposit at all. So you can still have a perfectly binding executory contract, which has a 0 deposit with a requirement to settle in 30 days. Likewise, as we've seen, there's no specific maximum, but if you go beyond 10%, then it becomes an instalment contract. But you're right. where you have a deposit which is $1,000 on a property worth $1 million, it's virtually a waste of time, particularly if you've got an agent involved, because the agent would be entitled to say, once you've recovered that $1,000, thank you very much, I'll have that for my commission. So why would you bother? One technique, and I don't think it's ever been adopted, but it's something I've mentioned to a few agents over the years, was why don't you ask for a 10% deposit, even if it's payable on the day of settlement? Now, there's nothing wrong at law in saying, well, the settlement will be on the 30th of September and the deposit is 10%, $1,000 now, and the balance of the deposit to bring it up to 10% is payable on the 30th of September. That way, if the buyer fails to settle on the 30th of December, not only can you forfeit the $1,000, but you now have the right to sue for the $99,000 unpaid deposit, and then it becomes worthwhile. Then there's some incentive. It's just an idea. In practice, I'm not sure I've ever seen it. It's fallen on deaf ears in the past, but that might be one way of getting around that problem in circumstances where the buyers said, well, we can't pay the money until settlement. But I agree with you.
Not so good for the buyer though, John, is it?
Not at all. Not at all, no. And
so you're showing a bias towards the sellers there?
No. Well, I guess in a way, well, I was talking to real estate agents, of course, at the time when I made that suggestion. But yeah, you're right. When you're acting for a buyer, you would have the complete opposite view. And there's two views on this. In terms of the amount of the deposit, in order to best protect your buyer, one is, and probably the one that applies in 95% of the cases, is keep the deposit zero or very low. But the contrary view that might be relevant in, say, 5% of cases is make the deposit very high. Make it intentionally 11%. Can you understand why? If the seller says, wow, that's really cheap, I'll only sell it to you at that price, which is dirt cheap, if I have a very good deposit and a short-term cash deal. So if your buyer is in that situation, maybe you're better off paying 11% than 10%, because then if you find that the buyer can't settle, time is no longer of the essence, it's an installment contract, and you're going to have a statutory guarantee of 30 days. So that's another way of looking at it.
That's the alternative argument for the buyer. Sounds good.
I'm just trying to settle it. Yeah, trying to be less biased. Thank you, Rachel. Thank you, Sarah, for that question.
Well, I guess with the problem with having a higher deposit though, for a buyer, is half the time they're relying on that money to get finance.
Yes,
so a lot of the banks won't even let you go much higher because they want it for themselves.
That's where cash is king, isn't it? Of course, if you've got the cash, you can set the terms as you want them, come in with a low price and say it's cash 14 days. But the little kicker is that it won't necessarily settle in the time. I was involved in a transaction once where we had almost exactly that situation, 11% deposit, 14-day settlement, cash deal, purchased very cheap because of that, and the buyer didn't settle on time, but knew the rules. Then the seller made the mistake of terminating the contract, purporting to forfeit the deposit. The buyer just sat back for a little while and then said, you can't do either of those things. I'm going to sue you because you've repudiated the contract and you've purported to forfeit the deposit where you didn't make you didn't provide the 30-day notice under the installment contract provisions. So again, you've got to be very careful both ways. All right. Well, thank you for those questions. Thank you for your participation. I really appreciate people attending for these sessions. And if there's any questions asked through UCrew during the week, I'll upload some material and we'll see you next week. All the best then. Bye.